When I look at this provision for registration, I remember this controversial bill about registering ICT professionals. And you start wondering, who are these ICT professionals to be registered? Because as we're saying, pretty much all of us in a day-to-day business are now dealing with ICT in one way or another. So do we all go get ourselves registered, and what does that mean? So that has been quite controversial. So when I think about it, extends in the same way to data usage and consumption. I know the law has talked about giving discretion to the data commissioner to consider issues such as the nature of the business, the volumes of data being processed. But I still think that again, pushing for something that's already been mentioned earlier, they should be pushing more for self-regulation, because a lot of these players dealing with data are already operating under other mandates in other industries. And that's where laws and policies have to really work together, not creating new silos.
But Joe, just to get back to what Prof was mentioning here, and why you can't rule out mischief in this, is because in March 2012, if you recall, the Communications Commission provided for the establishment of this new network early warning system, which was to monitor incoming, outgoing digital information. So definitely there is a concern around where Prof was coming in, don't you think so?
Again, until we understand, I guess, the rationale for the registration, it's very hard for to make a concrete comment around that, right? I think part of the explanation around the legislation should be to guide us. Why is it that you have specific provisions in here? If you compare, for example, the GDPR, even before you get to the substantive regulatory requirements, there's a whole explanatory memorandum that comes with that. And it goes on for pages and pages, and essentially just breaking it down to anyone who cares to read it, why it is we have put this particular provision and how it works in practice. So I would have hoped that we would have something similar with respect to this legislation. I would hope they will create that as part of the guidance to both individuals as well as organizations, so they have a better understanding why do you have these provisions in there. So otherwise, being the Kenyans we are prone to think of mischief, and think that there is something afoot here. We didn't want to Huduma number, we also
and even as he talks about, the question about Huduma number, which I remember taking one of the Kenyans who went last minute, just because there was some threat somewhere by somebody about getting this number. But when you think about it, where's the number? And while I support the need for government to have a unified registration, I really think it is important. So from that perspective of ensuring that we have something, we cannot be having silo offices where you go, births, then you go to. So on that basis, it is so important that we have that number. No question about it. The question is the processing, the storage, and how it is done. So that it's important that as we speak about this, not to misconceive the fact that we do need as a country to actually have a unified registration. We can't keep going for a license with a different number, then we go here for this. But how do we store that data?
But Prof, and addressing that we already have other identifiers that exist. So what happens to those existing databases if this becomes the true source of truth? So then what happens to the other information?
Which becomes the source of truth?
I get the right to be forgotten? Then on the other,
and what we should remember is that Kenya actually has the integrated people registration database, which harvests all this information from the birth registry, death registry, passport registry. So already there was an existing, but that, I guess that's a conversation for another day. I want to ask a question here which really bothered me yesterday. When I was reading this act, there are many businesses in this country which manage information or hold information in cloud. Which cloud is, the servers are not in Kenya. If you remember the 2017 elections, the servers were somewhere where outside the country. Do they fall within this the jurisdiction of the Data Protection Act? Because that's personal data.
They will. And again, we need to know when the commencement date kicks in. But yes, they will become subject to that, to the extent that you're holding personal data of Kenyans outside of Kenya. There's the provisions, the law requiring that you need then engage the Data Protection Commissioner around what are the safeguards you have in place, and even where they're being stored, this cloud, wherever it is, whoever operates the cloud, what assurances do you have regarding the safeguards they have for that personal data. So ultimately, there's still going to be an obligation on you as a primary collector of that information, who subsequently hands it over to a processor who's a cloud operator. You're still ultimately responsible for how that happens. So even as you choose your cloud operator, you then need to seek assurances from them and find a way of verifying how do you safeguard the personal data that that
Leonid is on your case before you even finish.
I remind them, like, I don't know if you have worked with any of these cloud service providers, for instance, because a lot of them are also governed by the laws of their land. So at what point then are you reaching out to DigitalOcean, who is a cloud service provider, and telling them, oh, you need to treat my Kenyan data in this way? And just before I finish that, it's no coincidence that this law was signed on the same day that Amazon Web Services announced that they were setting up a location here, and those Amazon Web Services is one of the major cloud providers around the world, and it's because of that expectation that there might be need to localize your data, that some data can only be stored within the borders of Kenya. And so for them, and for anyone who's in the cloud service provision, you see that's a new opportunity for business. Now, if there's a law that's mandating you to store data within the borders, then why not set up?
I think at the end of the day, if we have to localize, I mean, if we have to have data, for me, the question for a business, if I think as a business person, it's about cost.
Yes.
So first I think about cost, control. So are the costs reasonable if I'm doing them locally? But if I'm doing them locally, is the control in place? And is it as competitive as that internationally? So let's forget borders. Technology no longer in Thunderbird, we say, technology has no borders. We stopped borders. So if there are no borders, then how does whether it's local or international, are they meeting the same thresholds?
Exactly.
And I think for especially for data online, it must be with the same questions. You can't sort of put a lower threshold and say local data will have a lower threshold on control, on everything, and then we expect a higher threshold. Of course, I will choose the one that gives me better access for control.
And I don't mean to say that because you're localizing data, your thresholds are being lowered. In fact, that's an opportunity to easier comply because you can interface with the cloud service provider, as opposed to when they're seated in Europe or elsewhere. And then if you're asking them, because if this law is binding to processors, so people who, beyond yourself, who's collected the original data will be processing, there's the potential for tensions between the laws that govern their land and the laws that govern.
It creates opportunity for, I mean, we have an amazing, Kenya is competitively compared to, top of the South Africa, Morocco, Kenya, Ghana, Nigeria. I would probably say those are the top 5 countries with the biggest hub and tech populations across Africa. And Kenya leading in that process. And our tech population, I know Leonida from when she was a techie. You're looking at a hardcore techie lady here. And the techie community is big, and an opportunity for them to create localized spaces, but that they've got to do in groups, in teams, to think through the whole process of data control, costing, and everything. And I think maybe one of the things that we have not been great, and I'm talking to the community innovators in Kenya, is working in teams, and really thinking
advocating in
advocating
policy for that process, to be able to do that.
So and I agree with everything that my fellow panelists have said. I think for me, it's again just look at it in the context of so at one level, so the likes cloud operators like the Amazons and DigitalOcean, when you look at where they're regulated from, there's already similar legislation that applies to that. So they already have certain obligations regarding how they deal with personal data, and so for them, this will not necessarily be a different obligation, such that if you're requesting assurance from them that you have safeguards, you have mechanisms in place to protect personal data so that I can use your service, then they should be in a position to give you that sort of assurance. The obligation then on you as the Kenyan data collector who's about to use them is to then ensure, are you using you know, a processor that has those safeguards. So it comes down to your own decision, especially if your information is going to be held outside of Kenya. So it becomes a practical thing where you have a conversation with whoever the cloud provider is.
Yes.
You say where you regulated, where you situated, you know, what laws govern how you manage our data, and then you make an assessment.
Okay.
And you decide for yourself whether or not are they giving you that assurance. Because if they fail to do that, then you become then responsible.
But again, we've been talking about SMBs, smaller businesses.
Even
That
SMBs. You can ask the same questions even as an SMB.
I get it. I think Monica's touched on something about cost of compliance, and I think that's going to be a big issue because even in the GDPR situation, in as much as it was more open around issues such as registering, the cost has been a huge problem because for smaller players, even dealing with data breaches, you know, those fines that are being discussed, might be too punitive, if that makes sense.
I mean, if you look at Kenya on that point, Kenya's the cost is 5 million on the higher level.
Or 2%.
It's 1%. It's 1% of. So they've revised it, but then it's the higher of the two. So you know, between 5 million and 1% of turnover.
They've now made it lower.
Is it the lower of the two?
So you think it's
the lower of the two?
I think it was the higher. They've now switched
it off. So
it's
the higher. But the European Union's is 20 million euros on 4% of turnover, and you know so. Am I thinking it's lenient? Let me remove the small businesses, and I'm not looking at Leonida. But to be fair, I think we need to be really, that is low for big business. That's you're not. It's come on.
I want to react to that.
No, but before you react to that, Joe, my question is even before you talk about the breach and the penalties. The level of awareness around this particular law, especially among the businesses that will be affected most, and by that I mean the SMEs, is very scanty. And I'm wondering, depending on the commencement date of this regulation, of this law rather, it could have seriously negative, adverse effects on these businesses. Don't you think so? I mean,
I think it's important for us to sort of say, this, you know, Joe will speak to this, but I think usually when you have a law, there's usually a time frame.
A transition period.
This hasn't been provided. So I'm curious as to why not. Especially to allow for Kenyans to really come to terms with the fact that data is now a serious thing. It's no longer a joke. I think sometimes we think this conversation is for the ICT sector. It's not.
No, it's for the whole everyone.
It's for the whole country. And so there's really a need for the awareness to be laid down, and I think that is laid down through each sector speaking out about this. I think it's great that you, Julian, have gone ahead as nation to actually have this talked about. I think you'll need to do this in prime time and in all the different times, so that
I should tell my editors that.
so that then the understanding of what it means for data privacy is in place. And for the small businesses, it'll need that a lot of the MMEs and SMEs and are trained around this area, which is not something that has been, I wouldn't say something that has been done a lot in this country. So we've taken data, even on paper, our data on offline. Let's talk about offline data. Offline data in this country is very caviar. It's very nonchalant. Everybody takes it with, I put my ID somewhere. I put my name somewhere. When you tell last week, somebody asked me for my number somewhere, and I said, I'm not giving that to you. And she says, no, we need it. And I said, no, I've given you my name and my ID number. That is enough to identify me. You don't need my number again.
And they're not communicating the purpose.
Yes, because they're not communicating that. So if we have a very shallow understanding of data offline, imagine that impact online.
Yes.
So there's a need to balance as we think about data privacy, that we need to speak about offline data and online data. I think in this country, especially because for Kenya, a lot of us are not online. So offline data is going to be a big thing that we need to speak about, and not only see this data privacy as referring to online data. I think that's important.
Joe, you had a reaction before I get to Leonida there. Before you forget it.
No, I think I may even have forgotten it, but I'll pick up the point in any case, sort of going back to your, just sort of picking up of that conversation. And again, I've just lost my train of thought.
The offline data?
The offline data.
Yeah.
But can you talk about the pricing initially? The one I mentioned?
The cost.
The cost.
Yeah.
Yes. I mean, definitely this is going to pose a huge compliance burden. And I think cognizance of that, I would have expected the policymakers themselves to provide for a transition period. It is typical. We saw it, say, with the Companies Act, which, again, like this one, had been debated for years. Then, boom, one day, Companies Act 2015. And I can say that most organizations have not been ready for this revamped or revised Companies Act. And it's still a work in process even now. We're seeing a similar story now with data protection. Huge topical issue, lots of implications, but we're not a country that had an overarching law. So we should have been prepared so that we start understanding exactly what this means. And I know they will say that there was public participation, but it's one thing to really get people to understand, and as you say, the SME level, not just the large corporates, but what about the smaller end of town who are also going to be similarly impacted? So it should have provided, and I hope it can. It's not too late to
maybe
try
the
and
regulations
provide for. Yes, and so we'll see first of all when they come in and say, what's the commencement date? Do we have a long commencement, or are we going to sort of boom, it applies now? I think they should have phased and said particular provisions can be effective immediately. Others will need to come in at a certain later date. That's what we saw with the Companies Act. So,
When you look at the Act, there's a small section called privacy by design and by default. And why we are finding ourselves in this situation is because the way we've been building our different organizations and handling personal data has been, as she was saying, nonchalant, non-cavalier. But when you're setting up a business, really, I think it should be something away from the law, how you treat the data that you're processing. So the law should not come into place to tell you that you need to, put more respect to personal data, and that should have been in how you design even your business model, that we encrypt our data. We do 1, 2, 3, 4, 5 with it before we process it or put it on forward. So in terms of the issue of providing an opportunity to comply, I think, yes, it's necessary, just given the current bad practices in how we are treating data. But moving forward, whether there are regulations or not, I think people should just actively be thinking about how they treat personal data. And I mean, one of the biggest data innovations in this country is around financial inclusion and innovation. So when you start thinking about all these different people who have apps that are mining your phone for all sorts of data to give you a credit score or to allow you to access credit, they should have already been thinking about, if I'm going to read your messages, how am I treating that data? They should not wait for a law such as this to think about those issues. And so that idea of privacy and protection by design and by default, I think is a very strong
It's very strong,
principle.
but unfortunately, we're coming from Kenya, Africa, where some of these awarenesses are not in place. By design, usually starts from how even in school and how we learn about data and information and people and how we respect of persons, respect of person's identity, respect of someone's faith, respect all these little things that we sort of are not necessarily think through, even in how we learn. So to expect our society to have been at that level is, almost asking for something. I think we're asking for something different. I think in the Western society, that is already as a cultural thing. Somebody doesn't, today, if I'm greeted by you, Julian, you'll first greet me, and then some of people will still ask you, are you married? Are you single? These are, what is your other name? These are cultural norms that we have as Africans, and we need to be aware that these things then coincide with how we then write, how we inform, how we collect data. It comes from the culture. And so sometimes we may separate them, but they are cultural.
But I would like to qualify that to the extent that what I would say is that the fact that now it's a provision and it's in the law, it creates now the debate and the conversation. I don't think it is necessarily such a complex idea around this idea of privacy by design. Once you actually explain it, and you know, you're going to have you know, all measures of consultants, you know, and I'm not saying that because I'm a consultant, but, you know, the whole idea is that there are people to help you understand in practical, from a practical perspective, what does this mean? How do I design my privacy program to, you know, to reflect these principles of privacy by design or privacy by default? Is it in the way that, first of all, I build in a process or a control where I say, and I tell, for those people who are directly handling that information, remember, you must seek consent, you must disclose the purposes. As an organization, here are the purposes for which we are collecting this information for. So once you have that conversation, it will be this process of really now breaking it down and then identifying those purposes and ensuring that there's a procedure or process in your organization that keeps talking to that. And before you know it, it becomes part of
and this law, again, going back to the registration issue, so does it only apply to registered companies, or does it apply to broader data processors who might not necessarily be registered? Because that's where this issue of, we have to move away from saying it's culture to just in all our programs, whether we are regulated by the law or not, would still need to think about how we treat our personal data.
And on that point, Leonida, one of many questions that I'm receiving, and I will not mention their names because I've not sought their content. The thread generally is, if I'm running a business, and in this particular case, largely an SME, how should I expect to reconfigure my business to be compliant with this law? Because now that's the key question people ask themselves.
I think the first thing to start is, what is the purpose of me collecting that data? Start there. And then once there's a business you're clear, how do I then collect it and inform you the purpose upon which I'm collecting that data? I think Joe has said it, and I need a very clear, it's not complex. So let's remove the complexity around this. It's simple things like saying, we're going to be collecting this data because in the future we are able to identify this. Just that information is enough for me to be able to. And then, of course, how do I store it? So once I have collected it, the next question is, how do I store it? And I am assuring the person I'm collecting it from that it is stored, that their personal data is not, nobody can, can be hacked. And that storage, I know the law speaks to pseudonyms and stuff, but I mean, there's encryption technology today. There's different types of ways. There are several varieties in which you can actually store data, and different ways in which you can manipulate it to store it. So the question really is, how do I store it? And I ensure and I give a certainty to you, Julian, that your data is stored well. And if I give it to a third party, which ultimately most organizations do, that I take responsibility for the third parties I then forward this to. I think this is what fast business should do.
And if I just to add, especially that particular that particular point about where you use a third party to process your information, and the law itself is also fairly clear that if that processor were to deal with that information in a way that's not authorized or that's beyond the purpose that you as a collector gave them that information, then they become liable as principal, you know, for that for that misuse. So you have some measure of protection there as a data collector who's using other people's third parties. But you can also, you know, it's also about your contractual arrangement. So contracts are ways of allocating risk. So as much as if as a collector you're held primarily responsible, but your agreement with that data, with that third party, should ensure that there are certain provisions you put in there that say, in the event that you exceed or you do this, then in that situation you have to indemnify me. You know, and so you can still use those contractual risk provisions to mitigate against that risk. I think so
Joe, you're assuming that business the small business people understand
But to get the point,
in fact, I want to give a very practical way. No, I want to give a very practical, maybe solution to that scenario where you think you've not been compliant, but want to be compliant moving forward. So something that, and in as much as it was annoying, I was very grateful for, was when GDPR was passed last year.
Yes.
I received like 100 emails from different companies. Somehow I had maybe been on their website, signed up for something, and you know, had left my contact details there.
You didn't know who it was until they sent
I was like,
emails.
I didn't even know I was on this website. But they actually came back to every single person who they had that contact information for and told them, look, we would like to request consent now. And, you know, there's a place for, if you agree to continue receiving our services or working with us, you know, click here and we'll register you as, you know, as someone who gave consent. If not, this is the opportunity at which we then destroy your records from our system, and you know your right to be forgotten. And that was just an email blast, and they were able to reach their customer base, and they gave a timeline. So if you have like up to end of December or up to end of next year to respond to that email, if you don't, we assume you didn't provide consent. So that assumes you have the contacts of, which ideally if you're holding personal information, you should. If not, then you need to ask yourselves, like, how are you offering services to these people who you can't contact, right? So I found that a very practical way, because it's, you know, it's a quick blast. You reach out to all these people. Now they remember that they've given you their data and they can renew their consent.
And I think what I would add to that, in addition to those sort of practical tips, is that, again, we're not reinventing the wheel here. It's just that it's new in Kenya. But to be honest, even when you scour, even us as consultants, as lawyers, when we are trying to understand the legislation, we go to Google and we speak to counterparts, you know, other people where this legislation has been put in place to find out in practice how has this actually been embedded. So I think there is a wealth of service providers currently. You know, speak to your lawyers. You've got lawyers who've been tracking this legislation, who are able to at least at the very, you know, tell you these are your obligations. But beyond lawyers, you've got others who can come in, IT technicians, who are able to come in, review your systems, and help you configure to put in the appropriate sort of controls to ensure that information can be hacked, you know, and therefore doesn't put your business at risk. So there are professional advisors out there in the market. I'm not doing a pitch for PwC, but
definitely.
But and even as an SME, I think you start off by simply just asking yourself, what kind of personal information am I holding? That's just the initial question you have to ask yourself. I'm holding personal data. Where is it? Where is it located? Is it in HR? Is it with the sales guys? You know, how are they currently using it? And then come up even with a simple sort of, I know I make it sound simple, but when you think about it logically, just writing it down, you know, what are the reasons that I am collecting this information for? Then that portion you go into, you create a privacy statement, which you're going to share with your clients and whoever else you collect personal data from. And you know, it will set out for, in a logical fashion, sort of tracking what the obligations under the legislation are, and say, this is how we deal with your information. And if we're going to use it for other purposes, we'll make sure we come back to you and request your consent.
I think the challenge, Joe, has been that a lot of times, and maybe I'm speaking to the fact that if you're operating in Africa and Kenya is being in Africa, one of the challenges we have is the offline way we collect data. And a lot of it, many times, is collected very randomly. And so this act is really asking us to pause for 1 minute. It's asking us to pause and say, let's start with the collection. How do I collect data? And then, if I'm collecting it, am I so random about it? I ask you to fill a paper. Then from there, is that paper, is that book secure? Does it move to Julian?
Who moves it to someone else?
Who moves it to someone else?
To committee and
to someone else. So I think just, you know, as we pause back, it's just reminding us to be a little cautious and asking us to take some caution around collection of people's data. And if we're collecting it offline, I insist on the offline because this is where majority of a lot of our data is is the fraud happens. And then it moves to online fraud. But usually it's happened along the paper trail, especially within, where we are coming from in Kenya. And if we then go online and put this into a database, what are the securities around that database? Is it just on an Excel sheet that is open? Now, maybe I'm speaking, now I'm going to go into the tech language, but how accessible is that database that my data is sitting on? To what extent can anyone just come and access it? Is it encrypted so that I cannot even if I got to access it, I can't identify whose it is for? So these are the kind of things maybe to talk to as we think about that we need to educate the population of Kenya.
And it will be an ongoing conversation.
And just to, to kick this further on, I want us to get to the tail end where we are looking at, when you look at the law as it is, what are some of the key gaps that you identify and perhaps what you would propose in terms of remedying it? Lenita, please.
So exactly what Monica said, how to treat offline data. I think they tried to capture a bit of it through the, the exemptions for research, because it's pretty difficult to anonymize qualitative research data, for instance. But when it comes to, these other booklets that we are leaving our information on, or other places we are physically recording our information on, that right to be forgotten and to destroy my information from your records might be a bit difficult to implement if it's not on a digital system. So I think a little bit more thinking on how these data privacy laws protect physical data, and even just look at government. I know we're all digitizing now, but what happens to all those physical records? How will those be treated even as we have digital copies of it? Because those are originals. So thinking a lot about that offline process. That the other thing is the issue of consent. It's required for you to seek consent, but what we have seen with companies right now is they hide that consent in a lot of jargon. They'll be like, we'll get 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. It's a whole 6 pages of terms and services about how they'll use your data, and you say, fine, I agree, I'll do that. But the GDPR has set really good precedents in telling service providers that yes, have all the legalese, but break down the key things into something that ordinary people can understand. And then how again do you extend consent to offline communities? When you're treating health data, going to a health facility, a dispensary, like they need to be, I think health is actually very specifically covered in the law. So how is that dispensary treating your data when you register with them? So extensions to that offline activity, I think, is very important.
Joe?
I think my two areas. Firstly, I think there's around the category of what they call sensitive personal data. Information about your health, information about your political opinions, your sexual orientation, information that could probably be used to embarrass you or to the way that the legislation is currently drafted. I mean, when I compare, for example, with the GDPR makes it very clear that there are restrictions in you being able to collect that sort of information unless you bring yourself within certain exceptions, right? And so the drafting is very clear. I think apart from health, the way our provisions around sensitive personal data have been drafted are a little bit vague. So when I was reading that, I just found that that's not clear enough. If anything, since we were adopting so much of the GDPR, even that one we should have just copied the way it was. It was clearly set out. The other issue where I think clarification is required would also be around the obligations of processors versus the obligations of controllers, because right now, a lot of the provisions in our legislation seem to sort of equate the two. But again, if you go to look to the GDPR, you're going to see there's a clear statement of these are the obligations of the processors, and these are the obligations of the controllers. and therefore from going from that point on, then this, you know, the liability may flow. So I think we need that sort of clarification, and I'm sure there are others. Time constraints may not allow to go into too much detail, but yes, those are two examples.
Not to cover, my two colleagues have covered really a lot, but I think maybe to highlight the issue of consent, what I found the law being vague on is that they have some exclusions.
In the consent.
Yeah, in the consent.
Yes.
And I thought those exclusions really begin to create problems around. So you're telling me you can tell me after you've used my data. That, because I think that's what sort of it says. It sort of says, and let me use layman terms, says that, you know, I'll use your data, then I sort of come back and I told you. When you should really tell me before you use it.
It may not be practical.
It may not be practical. It says that. It says it's not practical. You know, that word. Yes. But at the same time, nonetheless, I think it creates grey. It allows room for mischief. And in, you know, with Kenya and where we are with information and how we use information today, and you know, I find mischief is always is an abuse. I think the second thing I want to highlight is fatigue, consent fatigue. The fatigue around ticking a box all the time. I think it's important for Kenyans now and Africans to really think back and say, what am I giving consent to? These are good questions to ask, especially with technology. Already, even in normal mobile phones and internet, a lot of things are assumed consented. So this is another thing I want to bring in. There are a lot of assumed consents that maybe when you check, and I do know the Act talks about children's rights specifically, or the law talks about children's rights specifically, but there are other things that are assumed consented. And so I think you need to knowingly know what is assumed consented. Even with our technology platforms today, there are many things that they collect data from you, you assume you consented to when you did not consent to. The fact that maybe your location tracker is on your mobile is an assumed consent when maybe you don't want your location tracker. I'm just giving that as an example. And finally, just to talk about, you know, offline. I have harped on it because I think this is where our problems are in offline data collection and data use, and then the processing. But the collection itself, I think there needs to be awareness. Our security agencies, the offices that you go to, any place you go to, the offline data collection in this country is not thought through. Many times it is just done, and we have accepted it as a norm because we say for security. But then it's important to think through why that's if for security, how sure am I that someone else cannot come and say, oh, that was her number, oh, that was her ID, okay. You know, so these are the things I think I'll just sort of, you know, end on as we think through.
And we have about 4 minutes to go, so I just really want to invite your closing comments. And I'll start with you, Leonida.
So again, now coming back from my background as an innovator in this data economy, this law is not necessarily a hindrance to the kind of work we're doing. I think it actually creates opportunities. He mentioned this mushrooming of consultants who can support you. Ideally, this is a new economic activity to support companies to comply to the law. But I'm looking at other directives that are already existing. For instance, in this EU area where we seem to be borrowing, there's the Payment Service Directive, which pushes for open banking principles or APIs where, you know, innovators and other people who are not necessarily the banks can build on top of existing payment service providers, and that requires sharing of data. So I think we just need to think a bit more how, like, this need to innovate, this need to capitalize on ongoing innovations and technologies does not hamper how we treat personal data. That at the end of the day, we are still human people. We still reserve a right to our privacy, and not to give in to the fact that, oh, they already have my data, so it's okay. Because I think that's an ongoing narrative that because they already have my data, what difference does it make if I refuse to consent? But that is a right that's now been enshrined in law, and that people should take seriously, and of course build that conversation between organizations that collect data and individuals who require services from them.
Okay. Joe, very briefly.
Okay. For me, this is a watershed legislation, and I think I'm supportive of its enactment. I think it is important in the context of where we are as a nation, you know, government pushing a digital agenda, a lot of businesses also coming online. I note the comment around also offline data. I think the legislation is broad enough to be able to cover that. There will need to be clarifications through subsequent guidelines and subsidiary regulations as to, in practice, how do we make this work and work in the context of Kenya. But it's certainly important for all of us to get engaged in the conversation, because as it is, and I go back to the point I made early in the session, that we are both data subjects, we are humans, my information is out there, I'm concerned how it's used. But at the same time, yes, we are also business, we are organizations, and we need to use that information. So it's a question of now striking that right balance, understanding the underlying importance of why that information should be safeguarded. And I think we will get there.
Prof, please.
I think it's interesting that this comes at, I agree with Joe, a watershed. That we actually have, finally after 6 years and so, a data privacy law. So with that, I must commend our government for that. I think it's important that we go back and ask for regulations. We have seen laws in this country enacted, but the regulations take forever. So I hope that this will not then be another 4 years of regulations, because then we will have defeated the purpose upon which this law was created. And I think, just to say, coming from Thunderbird School of Business, we now have an office in Africa. And the reason we're in Kenya as the hub for Africa is simply because we are really a watershed country in terms of the things that we are doing in technology. And so I think really grateful that we're beginning to break the marks. Let's have this conversation more. Let's have the idea of data discussed more. And I think we'll get somewhere.
All right.